Good afternoon, everyone. A warm welcome to the Connect University session on an overview of the Digital Services Act and the Digital Markets Act. My name is Andreea Dumitrașcu, and I'm part of the Connect University team, and I will share to present you the way today's session will run. Firstly, for those of you who are not yet familiarized with Connect University, this is the flagship of DigiConnect that aims to inform about the latest emerging technologies and digital trends. You can check our webpage for more information and also similar sessions. Thanks to all of you who registered for today's session in such high numbers. We invite everyone to connect on Slido using the code DSADMA. I repeat, the code for Slido is DSADMA. You can comment and ask questions via Slido and we will allocate them accordingly. In case you are encountering any technical issues with Slido, you can watch the session directly on YouTube and use Slido only for comments and questions. Also, we encourage you to use the hashtag ConnectUniversity when sharing insights on the event on social media. Without further ado, I would like to invite Mr. Prabhat Agarwal, Head of Unit Digital Services and Platforms, for the welcoming and introduction.
Thank you very much, Andrea, and thanks to all those who are watching and have taken the time inside the Commission and outside the Commission for spending your rainy afternoon in Brussels. It's rainy anyway. On an introduction, I will be doing this together with Irene Roch-Laguna, who is my deputy, and as part of the Connect University, we'll give you an overview of these two initiatives of the European Commission, first published on the 15th of December after a long period of preparation. In a nutshell, and maybe the one thing that you should take away from this in-depth presentation is that we are making a single set of rules for the whole European Union when it comes to online platforms. And those two are embodied in two different legal instruments that we will be presenting this afternoon to you, the Digital Services Act and the Digital Markets Act that we'll be explaining now in the next set of slides as we move on. Just to recall, what were we trying to achieve with these acts and that we have proposed, and what are the kind of objectives that we were pursuing? The first objective, mainly linked to the Digital Services Act, is to create a safer digital space in which users' rights are better protected and online, and where more effective methods are put in place when it comes to fighting illegal content in a single overarching EU framework. And the second objective we are trying to pursue is to establish a better level playing field in an environment where online platforms are now increasingly structuring our society, but also our economy, ensuring that we have new forms of innovation, growth, and competitiveness in the single market. And those are the two overarching high-level objectives that we were trying to pursue in the two proposals. Why do we need new rules? Well, there are a couple of reasons, and they are explained on the next slides. First, digital services have enormously developed over the last 20 years, when the last time the European Union put in place a set of horizontal rules. Horizontal means that they apply to all types of services across the board and all types of issues that are across the board. And in our jargon, the opposite of horizontal is sector-specific. For example, when we make special rules on subjects such as child sexual abuse material or terrorism online, those we refer to as sector-specific rules. But the underlying so-called horizontal framework has not really fundamentally evolved since the beginning of the century. And on the next slide, we'll illustrate a little bit some of the new big and small players. So on the one hand, we have, of course, the well-known in online platforms that you all use probably on a daily basis, and we all have now come to accept as part of our daily lives, and we use them. Many of us will struggle actually to function in their daily lives about it. So of course we all are familiar with the big names. But then let's not forget also that in the European Union there are many small innovators and many small innovative platforms. In our recent count, there are around 10,000 platforms in the European Union. Those are mainly micro enterprises. Around 42% of these are micro enterprises in the early growth phase of their innovation cycle. So this is a little bit the landscape. We have these very diverse and dispersed landscape. On the one hand, a small number of very big players, and then a landscape of very innovative new companies. And one of our objectives is also to help these small companies grow in an environment that is both geographically increasingly fragmented with national rules emerging, but also in terms of its competitive landscape, increasingly dominated by an environment with with a small number of large platforms. On the next slide, we'll show you a little bit on the evolution that has taken place, and I hand over immediately after this to my colleague Irene for a presentation of the Digital Services Act. But let me just end with this slideshow and just gives you a small overview of the kind of evolution that has happened over the last 20 years. And interestingly enough, the e-commerce directive was adopted around the first internet bubble in 2000, and the first major economic contraction after a big hype cycle. And many of the names that I mentioned on the previous slide, the big names, they were already around, but they were just emerging. And of course, the 20 years on, in 2021, two of the big differences are that on the one hand, the reach into society of many of these online platforms and the problems that have occurred are dramatically different. And in part, this is due to the AI-driven business model of many of these platforms, where advertising is placed based on click predictions, often triggered, often designed by very important applications of the advertising business model. So with this, I'll hand over to Irene, who will take you through the first part of the substantive presentations on the Digital Services Act.
Yes, thank you very much, Prabhat. Just a few words on this timeline. Just think yourselves, where were you in the year 2000? And imagine how was the situation when you wanted to buy something online. Or if you wanted to download a song, it was mainly illegal, and it took minutes, if not hours, because the connectivity was not the same. And just as an anecdote, Mr. Zuckerberg was 16 years old at that time. So time is ripe also to adapt the legislative framework to today's situation. But to do so, we have to be also very careful, because business models evolve constantly and faster than any policymaker can do it. So, for instance, our kids will probably not use Facebook or Twitter, because this is for old people. They find other innovative and always new ways to communicate with their peers. Or when we think of buying stuff in online marketplaces, we find that increasingly services which we consider under the little box of social networks are increasingly acting as online marketplaces. So when we regulate, we need to do it in a future-proof manner that allows also innovations to appear and to be adapted constantly. But also, we have to be aware that the fact that we use more and more the internet and all these innovative services that we love, that also helps the spread of illegal content. So we have seen during our impact assessment and analysis of evidence that obviously illegal content also spreads increasingly online, and we need to provide tools that allow us to fight and tackle this evolution. But also the other part of the problem is that illegal content is only a minimum part of content that is removed on a daily basis. Today, we see that almost 90% of the content that is removed is done based on private contracts, on the community standards or terms and conditions of the online platforms or online services that we use. So the last example is the one happening at the beginning of the year with ex-President Donald Trump, whose account was blocked by Twitter or Facebook or similar situations. But this is done in a unilateral way without any accountability, no transparency, and no possibility to challenge those decisions. And the last element that we need to take into account when considering new rules is that also member states are legislating in the field. So let's take the example of notice and action procedures. In the year 2000, when the e-commerce directive was adopted, the legislator did not put in place a common notice and action procedure, but it allowed member states to develop one. And so they did. We had some member states that legislated only for copyright. Others did it for copyright, but only for administrative authorities explicitly allowed in the field. Others allowed or imposed the statutory solutions for several or horizontal illegal content. Others only for defamation. And very recently, we have seen the evolution in some member states that intend to tackle illegal hate speech. So all this has brought quite a fragmented legal framework, which is difficult for all those small and medium enterprises that Prabhat was mentioning at the beginning to tackle with. Obviously, the biggest platforms might be able to enroll lawyers that can deal with 27 legal systems, but the smaller ones will definitely struggle. So this is why the Digital Services Act takes over those rules of the year 2000, the e-commerce directive, and adapt these rules to today's environment. And how do we do it? Under the e-commerce directive, we have rules that apply to all sorts of information society services. So not only the platforms that we always mention, but also any web shop that we might use, Decathlon.be or Carrefour, but also online newspapers or online games, and also obviously the platforms. And on top of these rules, it adds specific rules for those information society services that act as intermediaries. And for those rules, creates a sort of liability exemption for third-party content. And imposes a prohibition on member states to impose general monitoring obligations. So the DSA, the Digital Services Act, takes this last part of the e-commerce directive and moves it to the Digital Services Act. So the movement will mean that these rules change from the form of a directive to a regulation. And this will bring more uniform rules and the possibility for service providers to know exactly, to have one single set of rules. But then on top of these liability rules, we intend to clarify certain situations on liability for consumer-facing platforms, but also create a legal framework that incentivizes also proactive measures. And regardless of the situation as regards the legal liability, which is sometimes difficult to establish, it takes years in front of the courts, it is a case-by-case analysis. On top of that, we add a list of due diligence obligations. Let's call it responsibilities or duties of care that service providers, as we will see, will have to deal with regardless of the situation as regards the liability. And all these rules get accompanied with a common framework for its enforcement, both at national level via digital services coordinators that we ask member states to appoint, and the Commission as a facilitator, but also directly as enforcer, as we will see. And then the last point that I want to stress in this slide is that the relationship between the e-commerce directive and the sector-specific legislation that Prabhat mentioned, could be IP rights, could be terrorist content, child sexual abuse material. This relationship will be the same with the Digital Services Act. So we do not intend to change the relationship between the horizontal and the sector-specific rules. So in a nutshell, as I was saying, the DSA includes three sets of rules. One, the rules on liability that we take over from the e-commerce directive, the due diligence obligations, and a common framework for European governance and enforcement. As regards the liability regime, I think even if it's there for 20 years and those working in the field know very well what they are about, it is worth recalling some of the elements. First is that the e-commerce directive and the DSA intends to harmonize the liability exemptions, not the liability itself. So these rules would not attribute the liability. We would not say a service provider is liable under these conditions. What we harmonize are the conditions for the exemption of liability. They cannot be held liable unless they do not comply with certain conditions. It applies horizontally to all types of illegal content, be it criminal or civil liability. And whatever is considered illegal is not defined in this piece of law. It's defined elsewhere in national rules or in European rules when it is harmonized. It is service specific, and this is very important, that we want to establish rules for a given service. So if one service provider, if one actor, one big name that we consider provides different types of services, then the situation has to be judged as regards that specific service, not as regards the given provider. So with this change, the Digital Services Act intends to bring legal certainty and remove existing disincentives for voluntary measures. Because some platforms might consider that by putting in place voluntary measures to identify illegal content, they could be considered too active or too much involved in the content they host, and then they prefer to refrain from those measures and stay on the safe side. So we intend to avoid that negative incentive. And the last element that we want to stress during this change of rules on liability is to preserve a fair balance of fundamental rights. These rules are important in order to ensure that users can exercise freedom of expression and information online. And this is why we consider that they need to be kept together with the provision of general monitoring obligations. So one last word as regards liability is that we want to clarify that it is possible for national authorities, be it courts or national administrative authorities, depending on the legal system in each member state, to send orders directly to a service provider established in a different member state. So to say that the single market rules do not stand in the way for this direct enforcement. And this is important, for instance, in the field of the collaborative economy. If the city of Amsterdam, for instance, wants to request from Airbnb the removal of the listing of an apartment that has not been registered according to the Dutch laws, they can do it directly. And also, if they need the information about that apartment owner in order to enforce their national rules, they can ask directly Airbnb for that information. So going a bit deeper into the substance of the Digital Services Act, I would like to present the categories of services to which the different due diligence obligations apply. We have divided the Internet ecosystem of intermediaries between 4 different categories that act as concentric circles. And the biggest one is obviously the generic category of online intermediaries. It is not a concept that we have invented ourselves. It is already in the e-commerce directive in the liability regime that applies to intermediary services. So in the lowest level of the infrastructure, the internet infrastructure, we would find here the typical internet access providers, our internet providers, domain name registers, Wi-Fi hotspots, etc. So more the technical layer of the internet. Then the second layer would be represented by hosting services, which obviously include the platforms that we all talk about, but also the more technical hosting, cloud services, web hosting, etc. Then going a bit deeper into the content layer, we find the typical online marketplaces, the app stores, the collaborative economy platforms that I mentioned before, social networks. And then we provide certain rules for a subset of online platforms defined as very large online platforms that are represented by those that have a monthly average number of users equal or above 45 million users, which represents roughly 10% of the European population. So we restrict some obligations to this group because we consider that given their scale and their reach to such a high number of users and European citizens, they play a sort of role of public space that makes them able to take higher responsibilities. So in a nutshell, this slide intends to present all the full battery of due diligence obligations that we propose depending on the different category where a given service is put. So if you are more a technical service provider, you will be subject to the lightest level of obligations on the top in white. You are asked to appoint a single point of contact for the national authorities or for trusted flaggers, for instance. If you are established in a third country and you are not established in Europe, you need to appoint a legal representative, which is something that has been already established, for instance, in the GDPR or in the terrorist content proposal that has been recently agreed. The e-evidence proposal also includes this possibility. So it extends the rules also to services that are established outside Europe. And they need to be transparent as regards the terms and conditions and the content moderation measures that they propose. Last but not least, they need to have once a year a reporting exercise, a transparency report on the kind of measures that they have taken in the content moderation, if they are hosting services, on the notices received, orders received, etc. Then hosting services have to put in place a notice and action mechanism. And whenever they receive a notice from a private person, they need to give a statement of reasons, or whenever they remove content also based on the terms and conditions, they need to explain why. And that takes us to the next obligation on the next group. Online platforms will need to provide a complaint handling mechanism. So you are the user of a platform and your content has been removed. And you do not agree because you think your content is perfectly legal or does not collide with the terms and conditions that you agreed with. So you will have the possibility to complain about that removal. And if you still do not agree with the option taken by the platform, you have the possibility to have access to out-of-court mechanisms. Obviously, you can always go to court in your member state, but preferably the solution will be found easier via these out-of-court mechanisms. Also, they need to put in place a mechanism for trusted flaggers, which are usually entities that have expertise and knowledge about certain aspects of illegal content, and they need to act upon those notices more quickly. They need to take measures against abusive behavior, both for users and for notice providers. And for online marketplaces, they need to identify those third-party sellers or traders that use the online marketplace to put in the European market or to offer services that are not aligned with EU rules. Then they have some obligations to report criminal offenses in certain situations. And again, we find transparency reporting obligations. We will talk about that later. But the last group of obligations are those that apply to the very large online platforms. The idea is that all these due diligence obligations apply cumulatively. So the higher you are in the technological chain, then the more obligations you have. As you can see, many of those obligations apply to illegal content. When content is illegal, then the liability regime can apply. When content is illegal, you can send a notice, and the notice and action mechanism applies. Or when content is manifestly illegal, then platforms can put in place measures to avoid systematic abuse or misuse of those services, and they can report criminal offenses to the national authorities. But there are also other rules that apply to what we call harmful content that is not necessarily illegal, but it is also spread online. And it is important to stress that transparency measures, for instance, or risk mitigation measures by very large online platforms also apply to that content that is considered harmful. And usually the content considered harmful is dealt with under the terms and conditions of the service providers. So also some set of rules apply to content that has been, for instance, taken down or delisted, deranked, just hidden from the usual public because it simply goes against a private contract. So in those situations, as I said, the statement of reasons obligation applies, transparency obligations apply, the risk management obligations for very large online platforms apply, and also measures against content amplification, in particular when the content is harmful. So I would like to also explain a couple of words on the transparency obligations, which are all across the Digital Services Act in this group of due diligence obligations. Depending on the level in these four concentric groups that I mentioned before, they are subject to lighter or more stringent obligations of transparency. For instance, in the lightest level, we find obligations for the technical layer or for hosting services, where they have basic transparency obligations. They have to explain how many orders they received from national authorities, or how many notices, how much content they removed via their content moderation decisions, the number of complaints that they have received, etc. Then online platforms, on top of these basic transparency obligations, will also have to inform us on a yearly basis on the number of out-of-court disputes mechanisms, what was the solution, how many repeat offenders they have blocked or suspended, what kind of automated content moderation tools they use, if they use. And they have to inform also on twice a year on the number of users. So we want to get information from them as to how many users they have in order to find out whether they have grown so much that they have become a very large online platform. Because for all very large online platforms, we have specific transparency obligations. They have to report also on a yearly basis on the risk assessment that they are subject to, on which mitigating measures they adopt, audit reports, and also they need to give access to their data, not only to the regulator, to the Digital Services Coordinator or the Commission, but also to researchers that will have access to this information in order to allow a better understanding on how they comply with the Digital Services Act. So just a few words or a bit of a zoom on the accountability of the very large online platforms. Let's remember that whenever we talk about content regulation and about platforms regulation, at the end of the day, we all have in mind the big four, the big 10, and these are the ones that will be subject to the hardest level of obligations. They have the full set of obligations that I mentioned, and once a year, they have to be subject to an external audit that will check whether they really have complied with these obligations, but also with any code of conduct that they have signed to. And it's not that we are taking their word. We will also check whether this is the case via access to information, as I mentioned, but also they have to issue a risk assessment to check to what extent their systems, how they design their platform, can lead to further spread of illegal content, to damages or claims of fundamental rights, in particular freedom of expression, or unjustified discrimination, or that allows the manipulation of the services, for instance, to spread disinformation against public health, against some electoral processes that could harm minors, etc. The Commission intends to issue guidelines in order to identify the emerging risks and to also help those services propose the best or the most accurate risk mitigation measures. So a few words on the governance mechanism or framework for supervising the intermediary services that we talk about. We have a three-pillar system where at the national level, we ask member states to appoint a digital services coordinator, which could be a new regulator or could be one existing regulator. But in any case, they need to guarantee that this regulator acts in an independent way and supervises directly and coordinates the work of the national authorities as regards the enforcement of the Digital Services Act. This Digital Services Coordinator, of the 27 ones, will sit together in the European Board for Digital Services. We propose the creation of an independent advisory group that would advise the Commission and will be composed by those national digital coordinators and chaired by the Commission. The role of the board will be to advise the Digital Services Coordinator in the daily work of enforcement of the DSA, and also the Commission recommend actions and in general control and ensure that the DSA is applied consistently. Then in the third pillar, we have the European Commission ourselves. We have reserved ourselves an important role of enforcement. We propose direct enforcement powers as regards the very large online platforms, because we consider, and we have also seen in other instruments like the GDPR, that those platforms tend to concentrate in one or two member states, and they are bigger than any member state can provide intelligence and human resources in order to ensure the direct enforcement of those rules. So in order to avoid bottlenecks or problems for one given member state or two, we reserve this role for the Commission. And also, on top of that, we can advise on cross-border disputes and resolve the disputes, and can also intervene in case a digital service coordinator requests so. Obviously, all these rules would not bring much if we did not have the possibility to impose sanctions and fines in case of lack of compliance. So for that, the Digital Services Act proposes the possibility to impose sanctions and fines up to 6% of the provider's turnover. So it is even higher than the one in the GDPR, which is 4%. So in a nutshell, the Digital Services Act, as we propose it, will have benefits, positive benefits for four groups of stakeholders. Obviously, for citizens who will have access to more choice and lower prices via online marketplaces, for instance. They will be less exposed to illegal content, and they will be able to, we will be able to make use of our fundamental rights of freedom of expression, freedom of information, and protection of minors when we go online. For the platforms themselves or the intermediaries, they also benefit from the DSA because they will have legal certainty. We say clearly what are the rules of the game, and only one set of rules. They do not need to go to 27 legal systems to check what they have to do in its single case. That will make it easier for startups and scale-ups in Europe to grow and to compete with the big ones. But also the business users of those digital services, those of us, for instance, during the crisis, the small shop that intended to sell the products online and went to eBay or to Amazon Marketplace, they will have more rights and more security and legal certainty as regards their rights. Then for society at large, obviously, we get greater democratic control of the platforms, better oversight of how they develop their service, how they organize their systems, and we mitigate the systemic risks, the possibility that a big platform, just because they have a huge audience, they multiply the effect of illegal and harmful content. So just to finalize, what is the DSA in a nutshell? It respects the red lines that the Parliament and Member States have given us in the sense of respecting the principles behind the e-commerce directive that are still valid today, and in particular the liability provisions. But we modernize and we clarify and we make it more uniform. We promote the adoption of proactive measures, but we do not impose them. And we impose asymmetric due diligence obligations, depending on the size or the impact of the service providers. That will improve the fight against illegal and harmful content. It will empower users and stakeholders and will improve the transparency, as we have seen. And last but not least, we intend to improve the cooperation between the platforms or intermediaries and the authorities on the one hand, and among the authorities of different member states on the other. So I will stop here and I will be happy to take over questions that I have seen popping up in the dialogue as I was speaking. Thank you very much.
Many thanks to you, Irene, for the very comprehensive presentation. Indeed, we are receiving numerous questions via Slido from the participants. To reply to one of the main questions, indeed, the session will be recorded and it will be available for your review on the Connect University video space as of next week. So starting with the questions on the topic, we have the most voted question. Any concrete examples on how will citizens benefit from the new rules? I think you already mentioned a couple of them, but if you want to add something on this.
Yes, the citizens will be one of the main beneficiaries of the new rules. First, if our content gets deleted from one of our favorite platforms, we will have the right to know why, because they will have to inform us and to explain why the content was removed. And if we do not agree with that reasoning, then we will be able to complain and to decide that that particular contract or the illegality, if the case appears, was not correctly interpreted. So it gives us more redress on the one hand. Then on the second, it will also give us more safety, for instance, as regards products that are not compliant and get sold in online marketplaces, for instance, because online marketplaces will now be obliged to control or to check the identity of third-party sellers using the platform. So that will already disincentivize those rogue traders that intend to sell products in Europe that are non-compliant and it is not possible to enforce the existing rules. That will provide us with more safety in this particular area. But then also, in particular, as regards the very large online platforms, we ask them to check how the system is developed, how the system is designed, how they program the algorithm, in order to avoid the unintended result that content which is extremist, which is harmful, which is illegal, gets amplified, gets monetized, that there are incentives to share this content, which annoys us and annoys our children, for instance. So these are three particular examples. I could continue talking for hours on how citizens will be benefited from the Digital Services Act.
Thank you so much, Irene, for your reply. Moving to the next question. Are there rules of these types of national authorities which should enforce these provisions to ensure consistency across states?
I'm not sure I understood the question.
So are there rules on the types of national authorities which should enforce these provisions to ensure consistency across states?
Yeah, okay, I understand now. Actually, this is a very important question because, again, we need to repeat that this is a horizontal framework and it applies on fields where member states have already regulated or the European Union has already regulated. For instance, we have audiovisual media authorities that deal since very recently with video sharing platforms that are also covered by the Digital Services Act. Or there are telecom regulators that regulate also the system for internet service providers that they are also covered. So we have not imposed the role for a given authority at national level. We leave it to the member state to determine who will be the one sitting in the board or around the table. But in any case, what we want to be sure is that that authority is the one representing the views of all the national authorities that are responsible in this field. So the reply is is complicated because it will depend from one member state to the other who will be the one enforcing those rules.
Thank you so much. Moving to the next question. Well, what if the online is placed in a non-EU country? Member states can assure enforcement in this case also?
Yeah, this is a key question, and this is the question not only in the field of the DSA or the DMA, as we will see. This is a struggle that we are constantly facing also in the field of the GDPR, or we will see for the terrorist content. Obviously, we cannot work in a sort of a fortress Europe or a safety space where only European providers would be covered, and we would be safe only if we use the European providers. We think it is fair for a level playing field to apply the rules to those service providers established in a third country, but that they offer the services, or they direct the services to European citizens or European users. So in that case, obviously, enforcement is a challenge because they are somewhere in New Zealand or United States or elsewhere. But this is why we request them to appoint a legal representative in the European Union, only one. They do not need to have 27 legal representatives. And that legal representative will be the one that can be targeted for the enforcement measures. And then obviously it's for the legal representative to check to what extent they can make the service provider liable for those infringements.
Thank you so much. Moving to the next questions. Are the terms and conditions subject to any conditions? Can the terms and conditions be themselves abusive?
That's again a very good question, because we are moving in a very delicate balance between the freedom to contract. So if you are a private company, you are free to establish the terms and conditions, the contract that you offer to your users. But on the other hand, this freedom has to be exercised in a responsible manner and in a transparent manner. So what we request, we make clear you are free to establish the rules of your game in your space, but you need to be transparent on the rules so that the user knows in advance what are the rules of the game, in particular as regards content moderation, and that you apply them consistently, objectively, and in a non-discriminatory manner. You cannot say, today I accept your content and tomorrow I don't accept your content, when the situation is the same, or between two users that are in the same situation. And what we request from the service providers when they determine and when they apply the terms and conditions is that they do it with due regard to the user's fundamental rights. We cannot impose an obligation to respect fundamental rights, but on the other hand, they need to be aware of the damage that their decisions, in particular arbitrary decisions, could have.
Thank you so much for your reply on this. Moving to the next question. What defines that a flagger is trusted? Does each platform decide the criteria?
Yeah, this is the case today. Today, if you are, for instance, a rights holder association, you have to go to YouTube, you have to go to eBay, to the different services, and ask, please take me as a trusted flagger and accept that my notices are trustworthy. And it depends from to the platform to accept that situation. Under the DSA, we propose to put a public middleman. There will be the digital services coordinator who will be the one certifying who is the trusted flagger, the one who has experience and can demonstrate a high level of accuracy in the notices. This is usually very easy to demonstrate for the normal trusted flaggers, but also if they abuse that role, they can lose that status. So it is not the platform, the one who will determine to be a DSA trusted flagger, but it will be a public authority. On the other hand, the platform can always accept other third parties as trusted flaggers as they do today.
Many thanks. Going to the next question. Why aren't hosting services also subject to the complaint handling provision? Would the recent case of Parler and AWS not be in scope?
Again, a very good question. I see that our audience has read the Digital Services Act proposal very carefully. Indeed, this is a policy choice. We want to find the right balance between proportionate rules that do not impose a burden on those services that are not usually exposed to illegal content, and also the need to get effective measures. So what the option that we choose is for those hosting services that that we mentioned on Amazon Web Services, for instance. They need to put in place a notice and action mechanism. And also the smallest hosting service will have to put in place a notice and action mechanism because it's for the safety of the user. If I am confronted to a picture depicting a child sexual abuse, I want to notify it. I want to have that right. But on the other hand, we face services which are not usually used to disseminate the content. Or there is no interaction between users and the content. If you have your content in Dropbox, I am not going to your Dropbox account to see which pictures you have uploaded. So the need for a complaint mechanism is less relevant or less obvious for the more technical hosting services. So we intend to adjust and to attribute due diligence obligations there where they are most needed. Obviously, there will be a difference of opinions on whether we got the balance right, but indeed, this is the idea behind the whole proposal.
Many thanks. Moving to the next question. Will the Digital Services Act replace any sector-specific legislation?
No.
Okay, so this is a quick answer. Moving to the next one, define what is a user's views, clicks, and purchases. Are window shoppers users?
I did not understand the question, Prabhat. Can you repeat the question?
Sure. I will repeat the question. Define what is a user's views, clicks, or purchases. Are Windows shoppers users?
If you like, I can answer that question.
Sure, of course, please.
Yeah, that's a great question. So in the users as typically somebody who connects to a platform service and there is industry standard definitions, monthly average users that are being reported, for example, in the context of investment decisions and to say how many users a given TikTok service has in the news and so many users. And usually it is defined as somebody who takes a voluntary action per month on a particular platform, posts something or likes something or interacts with some kind of content. But since it is not exactly harmonized, actually, we have made a specific provision in the Digital Services Act also to lay down a common methodology on defining these important parameters so that we don't rely on an ambiguity of what exactly we are talking about, and that companies in scope have maximum certainty about how to calculate and how to define this.
Many thanks, Prabhat, for replying to this question. We will now move to the next one. How will or can DSA lower prices?
Well, by giving more choice to honest third-party sellers to compete. If you are competing with sellers from third countries who have not appointed a responsible person within the union and do not comply with with the rules on conformity for products, for instance, you are playing in an unfair situation, and your prices will be affected. So this cost will also be put at the cost of the user, of the customer. So in a way, the fact that we are improving the safety also for online marketplaces will have an indirect positive effect on the customers.
Many thanks for this clarification. Could you elaborate on the relationship between the DMA and the German GWB Novelle 10th Amendment to the Act Against Restraints of Competition? I guess this question can be taken when we will discuss about the later. Exactly. Okay, so moving to the next one. Do you expect that member states will demand big changes on the limited liability rules for platforms in the light of the storm on the US Capitol?
That's a good question. I don't have a crystal ball. I don't know what will happen in the next future. But what we have noticed is that member states also agree with us that the rules that we have on liability are resisted well the pass of time, and they have been interpreted by the court quite on a frequent basis. So they are alive and they are healthy. And what we have not seen from member states is clear indications that they would like to change the rules. So this is something that we will see in the coming months. But so far, I think they agree with us that these rules are to be retained.
Many thanks. Could Article 2020 of 22 of the DSA, Know Your Business Customer, be expanded to include infrastructure services relied upon for piracy and other illegal activity?
This is a good question. This is something that we were considering. But on the other hand, together with the Digital Services Act and the Digital Markets Act, the Commission has been working also on other proposals. And one day later, the Commission proposed the revision of the NIS Directive, the Networks and Infrastructure Services. And there we propose specific rules for domain name registrars, domain name registries, the DNS system, in order to get a better understanding and more transparency on the identity of their users. So we think that it is not necessarily under the DSA to extend an obligation, that it is very much focused on online marketplaces, because we understand that this is where the problem is more recurrent.
Many thanks. Moving to the next question, to clarify, will the VLOPs need to open up their algorithm to external scrutiny, example for researchers looking at disinformation?
Well, we don't think that we are not asking the platforms to reveal trade secrets. This has to be clear from the outset. We are not asking them to renounce to this very confidential information. But in any case, researchers will have privileged access to how they organize the content and how this algorithm works, in order to identify whether there are pitfalls, if you allow me, and the fact that these algorithms can lead to these risks, systemic risks, that we are identifying in the DSA.
Many thanks. What do you think will happen to Article 3 of the e-commerce directive, the internal market clause, after the DSA is adopted? Won't it lose force?
Actually, we think that it is the opposite. What we have seen is that Article 3 of the e-commerce directive is it's also in a healthy situation and has been interpreted by the Court of Justice very recently. And this shows that it is very alive. And by taking out the liability provisions from the e-commerce directive, we are removing one part that was more subject to discussion, and we put it in the relevant context. And we leave under the e-commerce directive, the general set of rules that really applies to e-commerce, to the way the internet is used by all kinds of information society services. So in a way, we reduce the pressure that was under the e-commerce directive, and also the pressure on Article 3, because member states will have a separate channel to coordinate their action in order to impede that online platforms or online intermediaries affect the way they respect their rules online.
Many thanks. Moving to the next question. Irene, you mentioned the deletion of Trump's Twitter account. Should platforms analyze the content of a tweet or its consequences?
In any case, not proactively. We do not ask them to filter and to check all the content that is uploaded. That would be first impossible, and second, it would be unnecessary surveillance. So what we ask, the examples that you mentioned, Twitter or Facebook, if they remove the content, they have to do it transparently, and they need to check against the terms and conditions, but then apply in a consistent way. If they receive a notice based on the law, or if they receive even more an order by a national authority or a national court saying that that content is illegal, they need to act. In a way, we are putting the rule of law in a higher level than normal contractual rules. So this is the impact that the DSA will have.
Many thanks. Another question before moving to the Digital Markets Act. Why did we not decide for interoperability obligations for very large platforms to break their network gatekeeper effect power?
Well, I think I will pass on this question, and we will see under the Digital Markets Act, which was the place where, if anything, we could think of interoperability measures. I think under the Digital Services Act, we are targeting content moderation and content rules, and not necessarily the need for interoperability. We do propose and promote standards, but not measures on interoperability among very large online platforms.
Many thanks. Now it's the time to move to the next presentation. So I will invite Mr. Prabhat Agarwal to tell us more about the Digital Markets Act.
Thank you very much, Andrea. And I will continue with the slide presentation. Let me just see if I can control it. 1 second. I do not see where I can control the slideshow.
Sure, absolutely no worries. Maybe we can take another question until the point you find the way the presentation will be managed, and the colleagues will also help you. So I'm going to ask Irene, how does this affect registries and registers of domain names? Will this affect the regulation on .eu? I think you're muted, Irene, if you can unmute yourself.
Yes, we are not affecting them in the sense that we are not changing the rules of how the domain name system works. So this is not something that will be regulated under the Digital Services Act. The only obligation that we ask for that level of service providers is to have a contact point in case they are contacted by a national authority, a national court, to put in place, to issue an order, or to have a legal representative if they are not established in the European Union. But we are not affecting the existing rules on how the system works today.
Many thanks for this. Just checking if Prabhat managed to upload the presentation so that we can move with the Digital Markets Act.
Okay, I think it should work now. So
we can see it.
You can see the slides, yeah?
Yes, we can see the slides. I can.
Very good. So I will take over now and continue with the Digital Markets Act, and I'll begin a little bit by showing you the background to the initiative here. So before I start speaking about the Digital Markets Act, I also want to stress on this particular file that this was a unique joint DG Connect, DG Grow, and DG Competition initiative, following very intense work together across all organizational boundaries last year, and bringing together, on the one hand, years of antitrust experience that DG Competition has built up, notably in the area of large online platforms, and also research work that has been done in the previous mandate, for example, the Special Advisors Report on platforms, and on the one hand, and on the other hand, experience that DG Connect and DG Grow had established, notably in the context of previous work that we had done on the platform to business regulation, and also work that we had done with an expert group on online platform economy, that and research that we had been carrying out for years on the dynamics, on the market related dynamics on online platforms. So last year we combined all this experience and combined our forces and to work towards a common proposal, which is a Digital Markets Act. And what is the basic driver behind the idea? What is so special about digital markets? And I think that the key idea here is, in one word, are network effects. And network effects are illustrated a little bit on this slide, and they're really a core of the platform economy. And network effects basically relate to the basic observation that in a platform like a search engine or a social network, the value of the network increases proportionate and to the number of users on both sides. So a social network becomes more and more valuable the more users you can connect, or a search engine becomes more and more valuable the more web pages it indexes on the one hand, but also on the other hand, the more users actually use the search engine, because it allows the quality of the search engine to improve. So in a nutshell, these network effects that scale very much with the size of the user base of a particular platform company, they increase the value of such a network, but they also make it very hard progressively for other competitors to enter, to compete and to have a contestable market, as we say in the jargon, by which some small number of players emerge, and this is a phenomenon known as market tipping, and this relatively small number of players tend to then be able to set conditions for trading that can be unfair, and this is something that we have been analyzing for years. And in a way, the Digital Markets Act sits on the one hand in the middle between the rules that we have on platform to business on the one hand, which captures all sorts of platforms and lays down some very basic transparency related rules, and on the other hand, the antitrust rules that continue, of course, to be applicable and that apply to a particular case of an abuse of a dominant enterprise. The main effect is a little bit illustrated in these cartoons, is that the result is, as we have observed, in unfair commercial practices and that cannot currently be effectively tackled in either the rules that we have laid down in the antitrust rules, which look at a specific company and that has to be established to be dominant and then demonstrated to have abused its dominance. Of course, the Commission has demonstrated this in a number of cases, or on the other hand, in the platform to business regulation, which covers a broad set of different actors. What are the problems that we identified, and what are the objectives that we are working towards? On the one hand, we have unfair gatekeeping practices that we said, weak contestability or risk of weak contestability of such markets, and we've also increasingly seen some regulatory fragmentation that has emerged. So a number of member states are observing the same phenomena and have started to consider rules. And of course, we might come back to that later, because I've already seen a question on this in the chat. And we also think that it's better to solve these problems at EU level, because of course the key feature of many of these platform markets and gatekeepers are that they operate across boundaries. They operate typically from across the entire European Union, and it's an inherently cross-border problem. In our view, these problems are better tackled at EU level than at national level, in generally speaking. So then we also have a set of objectives. We want to address these market failures that we've observed, and I'll come back to the sources of evidence in a minute. Address this unfair conduct that we have observed in individual cases, and then to also enhance a degree of coherence and legal certainty in the internal market. So what are the main concepts that we are playing with? And so this is just a word cloud here, just to give you some buzzwords or keywords that characterize the intervention here. On the one hand, contestability and fairness, I've already mentioned a few times, a harmonizing effect of these rules across the single market. We will speak about gatekeepers and emerging or current gatekeepers, lists of do's and don'ts you may have heard about in the past, also in some interventions by speeches by Executive Vice President Vestager. We want the rules to be future-proof and fast. This was something that has caused some frustration in particular cases, particularly in the cases of some of the antitrust cases, there's a sense in some quarters that the processes are maybe too slow to attack the problems before they arise or before the market tips. So speed is, but at the same time, of course, it's very much still also an important element to provide due process in these things. And so last buzzword I should say is maybe fines and remedies, but we'll come back to that at the end of the presentation as well. Now, what do we mean by gatekeeper? Who is a gatekeeper, and how do we define what a gatekeeper is? This was one of the key areas that we have spent a long time researching. The gatekeeper definition in the Digital Markets Act revolves around three basic criteria, and these are three conceptual criteria on the slide. And in the next slide, I'll show you a little bit on how we translate these concepts into measurable, quantifiable parameters. So a gatekeeper is one that provides a particular type of service, what we call a core platform service in the European Union. And examples of such core platform services are online search engines, or what we call online intermediation services. That's typically marketplaces and those kind of services, or a provider of an operating system. And there are some other types of services that you'll be familiar with, like social network services and video sharing platforms, and so on, that qualify as a core platform service. And this just takes me back to the previous slide that I have shown you, is that this definition recognizes in many ways that typically a gatekeeper platform doesn't have to, but can provide multiple such core platform services. So and they frequently draw their power, their network effects, and their their data-driven power from the combination of multiple core platform services. So we kept this list relatively open and broad, but the key feature here is that that core platform services are those kind of services in which these network effects that I started my presentation with are particularly strong. Multi-sided platforms with strong data-driven network effects. And so a gatekeeper is one that provides such a service, a company that provides such a service that has a significant impact on the internal market, that operates such a platform. So and this platform needs to be an important gateway. So it's not just enough, and we'll come to that in a minute, that you have a platform service, but it needs to be also an important gateway between business users and end users. And this is a concept I'll come to in a minute. If you look at some of the well-known services that you might be using to buy Christmas presents or Valentine's gifts coming up, what you see is that some of the gatekeeper platforms, they have this enormous end user base, millions and millions of users or tens of millions of users in the European Union on the one hand. And on the other hand, they have a very substantial part of business users. So a lot of trade flows through a very small number of these gatekeeper platforms. So this is also, some other reports have called them bottleneck platforms, or platforms with strategic market status, or in literature, also in the academic literature, these are known as choke points of the digital economy. So the third concept here in the definition of gatekeeper is that that there is some stability to this position. This is not just a flash in the pan. This is not just a one-off event. This is not just a quick fire thing, but this position of being an important gateway has been there for some time. It is entrenched and durable. And this reflects the fact that, of course, in the digital economy, unlike in the physical economy to a certain extent, where these zero marginal cost effects are less well developed, that businesses also sometimes appear and disappear very rapidly. So this is not where we are looking. We're looking at those kind of platforms, those kind of gatekeepers that enjoy this position for a number of years, and that gives us a good indication that these platforms have this degree of entrenchment. They are designated through a particular process, which is spelled out in the regulation. This process has a flowchart that I'll come to in a minute. But it's important to just notice here, maybe for those who on a Thursday evening might be already a bit saturated with the details, that it's a mix of qualitative and quantitative parameters. So we are using some hard black letter rules about quantitative parameters, but we have some flexibility in the system, and that comes in two ways. So the flexibility can be rebutted. So if you are designated a gatekeeper, you can, under very specific circumstances, say, well, I meet these thresholds, but actually, hold on, I'm not a gatekeeper. But you have to then prove that, and the Commission has to take a view in it. Or the other way around, then there might be cases where a particular platform is a gatekeeper, but doesn't meet the quantitative criteria that I'll outline in a minute. But where the Commission has powers to carry out a market investigation and to go into, I'm sorry, I just want to go back one slide here. Oh, one second. Sorry, apologies for the bad slide control. So what are the numbers that we have? So so there's a quantitative parameter which links to its annual turnover for the last 3 fiscal years, or an average market capitalization, or the equivalent in fair market value in the last fiscal year. So this is a size criterion. So in the European Union, you have a large turnover. That means that you have a large user base that you are already monetizing. This monetization, therefore, means that the engine of data-driven network effects and is in full swing. And you have to have a core platform service that is available in at least 3 member states. This captures a little bit the European Union dimension. We're less interested here in companies that are kind of only big in one particular market, and that's not our primary concern. We're looking really at gatekeeper platforms that have this kind of cross-border, EU-wide, internal market relevant effect. What is an important gateway is that if you have a number of monthly users, active end users, that's about 45 million users in the European Union. That's aligned with what Irene had presented on the previous slideshow on the Digital Services Act. That's 10% of the EU population. And you have a sizable number of yearly active business users established in the union in the last fiscal year. So this is this just again captures this gatekeeper power in a very visual way. You have 45 million users in the European Union. That's spread out over many countries typically, but at the same time, at least 10,000 businesses are using your service to reach the other consumers, and so this is what we mean in a quantitative way by being an important gateway. And a entrenched and durable position is if you have had these numbers for the last 3 years. So this is something that captures for 3 years. You've been maintaining this this large user base, and so kind of oscillations and fluctuations and peaks are not captured in this way. So this is a little bit what we mean by these quantitative thresholds and how we make hard the concepts on the left side here, and the criteria here that are on the right side. So I think I forgot to say the numbers for the turnover are 6.5 billion euros. That's where we place the needle, and 45 million active end users and 10,000 yearly active business users. And so this was now. I should say maybe before I go into the next slide, because I said that I promised that I say a little bit more. Well, how do we come to all these numbers? And how do we come to all these concepts? I mean, what kind of ideas did we do? So, of course, we carried out a very thorough impact assessment in the past year. But it's just important to notice that some of the inputs to this work, intellectually, but also in terms of research, have really had a long history of global work as well. So there have been many reports. I already mentioned a special advisor report to Executive Vice President Vestager in the last mandate. In the meantime, there were also similar reports issued in the United Kingdom, in the US, Stigler Center in Australia, but also inside Europe. There were a number of reports that were coming to similar conclusions by the Dutch National Competition Authority and French government. Trésor issued a paper going along, and also importantly a German reflection paper, Wettbewerb 4.0, and many other reports as well. Just to give you a long, and there's in between all of these reports, there was a remarkable convergence on the basic concepts that we've translated here into these criteria. That's one thing. So then on top of that, we carried out, of course, a thorough public consultation and a survey. We used the work of the online observatory also to analyze a range of these practices that we've been, and the concepts that are here. This expert group has been very active in supporting the impact assessment with research. We had a long-standing cooperation with the Joint Research Center, who have done a lot of work on the economic analysis in the background. And then, of course, and this is also very important, we've built a lot of our work very much on also the experience on antitrust enforcement that has been gathered over the last decade or so in many of these in investigating and then enforcing competition rules, particularly against many of the gatekeeper platforms. Here's a kind of list. I mentioned already that a key concept of a gatekeeper means that you operate a core platform service, so this is just restating what I've already said. Is that that these are some examples of core platform services. Online intermediation service. This is a legal notion that was already introduced in the platform to business regulation. Search engines, operating systems, cloud computing services, video sharing platforms, messenger services, and social networking sites. And we also included the importance in the definition of running advertising services as well, which is well established as a strong source of these network effects on top. Then I just want to come to I think I've already covered this, the numbers of what we mean, 6.5 billion in the last 3 financial years, or an average market capitalization of 65 billion in the last financial year. Maybe just worth pausing on this, or in the beginning there, just to say, well, we have turnover or market capitalization. I think this tries to capture the important case where actually the stock market is valuing you at a high price, because there's good promise that you will soon monetize the large user base, but you have maybe not already done it as a gatekeeper platform. And this reflects the fact, really also another strong characteristic in the platform economy is that that frequently users are added and investments are made prior to any turnover actually being realized. Prior to the lockdown, those who lived in Brussels would have seen a lot of the Lime scooters or the around Brussels, and of course many of these scooter companies, they wanted to win users, and it was a first mover advantage that was very important, because the a network that would have a maximum number of users would then be able to deploy these data-driven network effects and therefore perhaps tip the market and have this first mover. But of course, this was all done without really realizing any turnover yet. And so, in order to capture this very common characteristics of online platforms and gatekeeper platforms, that they may be running an operational loss, but the market capitalization is high, we've introduced this other criterion as an alternative there. Now, the user base I've already mentioned. Here's a flowchart a little bit on the flexibility part that I mentioned earlier in the Digital Markets Act. So on the one hand, we have these quantitative thresholds that we have just repeated in the previous slide, and reflecting these three concepts here. And then there is an obligation, if you are a gatekeeper, to notify that you fulfill these criteria, and then a designation decision is taken by the Commission. Or if you want to make use of this special feature saying that I meet these criteria quantitatively, but for some special reason I should not be considered a gatekeeper, we have a very tightly and narrowly circumscribed rebuttal procedure that is outlined. So there's a possibility, but we've carefully tried to draft it in such a way that this doesn't become a kind of endless cat and mouse game, and this is a flexibility element here, but within very narrow boundaries. There is the possibility that I already mentioned earlier of opening a market investigation in the Digital Markets Act, and the purpose of such a market investigation is precisely to identify emerging gatekeepers, so gatekeepers that may not meet the quantitative criteria, but they might very well act like a gatekeeper. And there's a process outlined here, which is quite a fast process, where preliminary findings are published within a very short period of 3 months, and then a decision is taken within something like 5 months. So this is a little bit the procedural framework, if you like, to explain how we work around both this mix of quantitative and qualitative criteria. Now, what happens if you have been found to be a gatekeeper? Well, if you are a gatekeeper, according to this regulation, then a series of obligations start applying to you. So here is a kind of an overview of these obligations, and they come in two categories in the regulations. Those which we call directly implementable. Those is a category of practices which are clearly defined, egregious practices that are just simply disallowed. We used to call them, or some other people call them, blacklist clauses. We've dropped using that terminology. So we now speak about directly implementable obligations, and they have very limited escape clauses. Only for public security or public health you can claim an exemptions and under very special circumstances. But by and large, if you are a gatekeeper and you engage in any of the practices that are on the list in Article 5, for those who want to look at the regulation, then they apply immediately, and this is conduct that you should not engage with. And of course, I would say that later on again, once more, the idea is not necessarily that we expect many gatekeepers suddenly to breach this, but there are, of course, the intended obligation, the intended effect of this regulation is that the signaling power of these prohibitions is such that these practices are not engaged with in the first place. So then there's a second category of obligations susceptible to further measures. Those are also clearly defined, but they might require a dialogue with the Commission in this case on how exactly they should be implemented. And this recognizes the fact that there's a category of unfair behavior where a dialogue is useful in saying, well, you are doing this, but there is a possibility of discussing exactly how a gatekeeper should address a particular conduct and therefore come into compliance with the regulation. That's a little bit too. So basically, two big categories of obligations. In many cases, there are prohibitions. They're not always prohibitions, but so those who, and so once you are a gatekeeper, both of these are directly applicable. Of course, in the second box here at the bottom, there's a direct there's a dialogue available as well. Now, as I mentioned earlier, there's a special provision for what's known as emerging gatekeepers. So those gatekeepers that don't yet meet the criteria of the thresholds that I mentioned earlier on, and then they might be qualified as emerging gatekeeper. But it's important for us to have a look at those as well, and the DMA gives us a vehicle as well. And it's precisely this market tipping logic that is so important there, where we would like to intervene and be able to intervene prior to a lack of contestability, which can then be very difficult, if not impossible, to reverse. And in that particular case, we could apply some of these obligations in a narrower manner. Just I'll give you just some examples of obligations and unfair practices instead of exposing the entire catalog of practices here, and so let me give you a bit of flavor. Of course, it's much discussed in many of the reports that I mentioned earlier, and also in the literature, but also in the public consultation, when many stakeholders gave us good and very high quality evidence that commercially sensitive data of business users is used by the Gatekeeper platform as well, and for sometimes to optimize their own service, and that is a practice give you an example. You work on you provide your service or your goods on a platform, and in order to provide your service, you have to make available some commercially sensitive data, and then you find that platform competing against you on the basis of such sensitive data. This is a practice that we prohibit here. Not giving effective data portability rights is an obligation. So it's an obligation to provide effective data portability rights. These are rights that are very useful in increasing contestability, because they allow some degree of switching from one platform to another one. I've shown you from in the beginning, right at the introduction, that network effects, they may make switching particularly easy, because in some cases you need to take your whole network. If you are on Facebook and you want to go to another platform, then you also have to migrate your whole friends with you. And so there are kind of intrinsic barriers that make switching very difficult in some of these network platforms. And using enhanced data portability rights, such as the ones that we have foreseen here, is a very good way of the contestability of the markets. There's a category of practices which we call unfair favorable treatment, and that is sometimes when a platform offers a particular platform, the Gatekeeper service or the core platform service, but also is active on the same platform service itself. And an example of the kind of practice that we have there is that it is well documented in our research that frequently such gatekeepers prevent the promotion or access to conclude contracts with customers outside of the Gatekeeper platforms, keeping everybody in this Gatekeeper environment, and preventing users from also concluding contracts outside. And this, of course, then amplifies the choking effect, if you like, and increases incredible dependency on the stranglehold, if you like, on the relationship. And that is something that we've also addressed here in through a particular prohibition or obligation on unfair favorable treatment. There's one more, there are two more that I'd like to mention here. And again, I think it's just important to stress that these are examples. I invite you to look. I mean, in the time that we have today, it's not really possible to go through the full catalog of practices. But another one, which I think is quite important, is that when you provide access to a Gatekeeper platform, you must do so on fair and non-discriminatory conditions. So it's not arbitrary or discriminatory, and this reflects the fact that if you are such an important gatekeeper, well, then you must have some minimum degree of fairness and non-discrimination in who can access it, because you become this basically important gateway that you are affecting, and if you are operating such an important gateway, then you must play by some ground rules of fairness and non-discrimination. Also, a range of advertising-related practices there. We've also looked at the issue that's very much also in the news of consumer profiling through a transparency obligation here. And so here is something that has particularly been brought to our attention in the context of online advertising, which is, as I said at the beginning, an important source of strength of network effects, is to give advertisers and publishers information on the price paid by the advertiser and price paid to the publisher for a particular ad. And this is an important accountability tool, and preventing access to this, in our view, is a form of an unfair practice that we also have addressed in this regulation. I'm slowly coming to the end of my presentation, and I'm looking forward to the many questions I see already in the chat. But just to conclude, there's also a well-developed enforcement and governance system in the Digital Markets Act. And of course, that consists on the one hand on the standard investigation powers that are well known from antitrust investigation or competition law in general, ability to take interviews, on-site inspections, and requests for information. Important to say that we've also mirrored them in the Digital Services Act. So some of these obligations under enforcement and governance are identical in both of these acts. There are some enforcement powers, such as non-compliance decisions that can lead to interim measures, so orders to do certain things, or fines. If you are in breach of the obligations, there might be periodic penalty payments. You can voluntarily put yourself into compliance, but subject to a certain dialogue. And if you are systematically infringing, well, then there are some far-reaching or possibilities as well. Additional measures can apply, and they can include, and we should have put it on the slide, also a structural separation of the infringing gatekeeper platform. We bring together expertise that exists in member states through an advisory committee, because, of course, some of these issues have also been analyzed and reflected in member states. And we pull all of that expertise together into a digital markets advisory committee. So maybe just to very briefly summarize what we have in the DMA. We have a single rule book for the European Union to ensure contestability and fairness in those markets where gatekeepers are in a way modifying the competitive dynamics and reduce contestability of the markets that has led us to make these proposals. The scope of our proposal is limited to gatekeepers. Gatekeepers are those that offer core platform service in the Union in more than 3 member states, and they have a large user base, both in terms of end users and business users. There's a designation process based on quantitative criteria. Mentioned them already: 6.5 billion euros turnover in the European Union, or 65 billion market cap, and at the same time a presence in 3 countries. Or it's these quantitative criteria can be rebutted and by a gatekeeper who can make a claim that they are not a gatekeeper, and then be subject to a further investigation, but then it's always leading to a designation decision if it's not found valid, that rebuttal, or based on a qualitative assessment, as I've also mentioned, subject to also in part through a market investigation, as I'll say at the bottom of the slide. Once you are a gatekeeper, then you are subject to a set of obligations, a catalog of obligations. Some of them can be further specified. There's some flexibility towards gatekeepers that are emerging, so that are expected to enjoy a durable entrenched position in the future. So some flexibility is envisaged there. And a framework for market investigations is also laid down to designate such gatekeepers and analyze new harmful behaviors, and also apply remedies for non-compliance. We will pool together the expertise of the member states through this advisory committee that I just mentioned on the previous slide. I think I have 2 more slides. Second. So just if Irene allows me to just bring the 2 put together in a nutshell, the takeaway messages after this long session here, and if your brain is not yet fried, here's the take-home slide. The Digital Services Act on the left side is intended to ensure the proper functioning of the digital single market for digital services, unified conditions to allow particular European innovators to scale up, but also secure a safe online environment with a responsibility and accountability frameworks, in particular for the largest online platforms. This framework is designed to protect users' fundamental rights and empower users and protect the freedom of expression in particular, and also to establish the appropriate supervision of online intermediaries and cooperation with authorities. This is really, in a nutshell, the Digital Services Act. And Irene already explained how this is articulated across different types and sizes of services. Whereas the Digital Markets Act aims at fair and contestable market conditions, where in markets where gatekeepers play a strong role. And we want these markets to remain contestable. Enable business users to bring innovative services also to the market without by loosening a little bit the stranglehold that they have experiencing right now, and empower customers also to freely choose the services that they would like to use, sometimes outside of the gatekeeper platforms. We believe that together they enhance coherence and legal certainty for all market operators, in particular because these rules are uniform and meant to apply across the board. So with that, Andrea, happy to take some questions and wrap up. I think we're almost out of time.
Thank you so much, Prabhat, for the very comprehensive presentation. Indeed, we have numerous questions coming in via Slido. We'll make sure that we will reply to the majority of them. Otherwise, the colleagues will be happy to go on Slido and to reply there after the session. So starting with the first question, can you elaborate on the European Commission's internal organization for implementation and enforcement of DMA rules? Will your competition colleagues lead market investigations?
That's a great question. At the moment, I think this is all not yet decided yet. I mean, because also it's looking a little bit into a distant future. We have just begun the presentation of these proposals in the European Council and in the European Parliament, so we're still some way off from an agreement. But what I can say is that we have done this as a team, and we expect also to continue as a team going forward. Exactly how the division of the enforcement and implementation responsibility will be decided, I think that will be discussed at a later stage. But it's clear that it will be. We will continue the very good teamwork that has characterized also the work that we did last year.
Thank you so much. Regarding draft DMA, I got the feeling that it was very much written with certain current dominant platforms in mind. How do you guarantee the act is future-proof? Is asking a colleague from OP.
Thank you. That's a great question. So there are various sources of future-proofness in, and it's important that I stress here that we have designed the criteria in an objective, non-discriminatory way. We did not pick any particular platforms and say you need to be in scope or you should be in scope. Instead, we looked at the characteristics of the markets that we have studied together across the Commission for many years, and we have captured the market characteristics, as I said, in these conceptual criteria and then also in the quantitative criteria. How do we ensure that they are future-proof? Well, through various means. One important means is through the construct itself. If another platform becomes big in the European Union in the future, then it will acquire a large user base over time, and it will then fall into the obligations of the Digital Markets Act. So, for example, we can foresee that in the near future there might very well be more Chinese platforms in the European Union who are very popular in Asia at the moment, and it is conceivable that more than just one or two will become popular also in the European Union. Well, if they acquire a large enough user base and they operate, they fulfill the criteria, then they would also be captured in this. So this is one source of future-proofness. The second source of future-proofing comes through the two elements of flexibility that I mentioned. One is this foreseeable status of a gatekeeper. So there's this provision that I mentioned whereby we can say, well, this might become a gatekeeper, in which case we have some flexibility of applying a subset of rules, subject, of course, to a due process obligation as well. And then last but not least, the market investigation aspect, which allows us to also investigate markets that are emerging and to make findings of gatekeepers or conducts that might be problematic in the future, and that's also another way of making it future-proof.
Many thanks for replying to this. Moving to the next question. Since obligations and prohibitions are very inspired from very specific antitrust cases, do you believe they can fit for all, apply to different business models?
That's a great question. Indeed, we have drawn, as I said at the outset, very heavily on the experience in antitrust cases, but we also seen some of this conduct come over and over again, also outside of the case of the situation of antitrust. So there is a little bit of nuance in the obligations. I mean, some of these obligations don't necessarily apply to everybody. So some of them are specific to providers of advertising services or operators of search engines or so on. And of course, if you are a gatekeeper and you are not providing none of these things, then the rule also doesn't apply. So there's a bit of graduation there. But in general, I think that what we want to say is that these practices that we have captured here are recurrent issues that have come not only from antitrust investigations, but also from our extensive fact-finding and background research that we carried out.
Many thanks, Prabhat. Moving to the next question. How do the very large online platforms have to reveal algorithm details, and is access to data for researchers only on request?
Yeah, I think, Andrea, this is a question we already answered this is more a question for the DSA, and I think Irene tried to answer that. This is for the data access regime under the Digital Services Act. And we said that, well, we will not ask companies to reveal their trade secrets, but also from our experience, notably, for example, on the search ranking provisions in the platform to business regulation, we know that there's a wide margin between giving up trade secrets and meaningful transparency and accountability. So that's more a question aimed at the Digital Services Act, but it's a good question.
Many thanks. Going to the question that one of our colleagues asked earlier on the DMA, could you elaborate on the relationship between the DMA and the German GWB Novelle 10th Amendment to the Act Against Restraints of Competition?
Yeah, that's a great question. I mean, the person who's asking this is obviously an expert in the area, because it's a question. So it is the Digital Markets Act has specified in its introductory articles that national rules prohibiting anti-competitive agreements or decisions by associations and undertaking and so on, and national competition rules prohibiting other forms of unilateral conduct are not affected by this regulation. So to the extent that this new German law it meets these criteria of being a national competition rules prohibiting other forms of unilateral conduct, they will be remaining unaffected. Of course, if the rules overlap with the specific rules and under the DMA or contradict, then of course, like in every case, the EU law will prevail.
Many thanks. How will the DMA DSA affect online advertising and micro-targeting? Targeted online advertisement has provoked a lot of criticism since Cambridge Analytica. That's
a great question. So I think that we've been really looking at micro-targeting and targeting practices a lot, also with colleagues from data protection side. First thing to state is that some micro-targeting practices are already in scope of the general data protection regulation and also to some extent e-privacy regulation. So the privacy-related the privacy-related issues of micro-targeting, where personal data is used without consent, for example, those have to be addressed in existing privacy regulation, and that's something that we are building on top. What we are doing in the DSA and the DMA is providing a really strong set of transparency and accountability rules that empower users to know how their data is being used. For example, in the DSA, there's a rule that says that platforms have to provide information on why is this ad being shown to me, what kind of data are you using to target me with this ad, and this in turn empowers users to take their rights in their own hands. In the DMA, there's also audit obligation on all the techniques that a gatekeeper platforms use it to profile consumer, because this has also been a concern. I need to stress one thing that we do is in the DSA, in this context, is also we are allowing users to have options, for example, on recommender systems. Those are typically artificial intelligence systems that show you on YouTube the next up content that Irina also mentioned earlier. And they allow users to opt out of personalization or profiling-based recommender systems. So this is the kind of logic of the approach overall.
Many thanks for this reply. Moving to the next question, what do you respond to people claiming the thresholds are too low and therefore capturing more actors than the expected suspects?
I respond that the thresholds are just right. This has been very carefully assessed in the impact assessment. I mean, of course, there are choices that we also assessed, but it is important to find the balance between going too narrow and going too wide in the proposal. I think what we have put on the table is a reasonable, fairly balanced offer. For such a balance, I think it would be a mistake if only a very small number of companies would be in scope. I think that we see these network effects important also below a certain absolute dominance effect. This is the whole point, as I said at the beginning. These rules sit between the antitrust rules that apply to very dominant players and the platform to business rules that apply to many 10,000 players.
Many thanks. Moving to the next question. Is there any potential link in the DSA to GDPR or the Data Governance Act? Online platforms are managing a huge amount of personal data. This is, it is at the core of the problems that we're trying to tackle. And for example, the provisions on data use that are in the Digital Markets Act or the advertising transparency rules in the Digital Services Act, they head-on attack this problem of using personal data in order to unfold these network effects. However, it needs to be stressed that we already have a very strong framework when it comes to personal data protection in the GDPR and hopefully also soon in the e-privacy regulation that is still being negotiated. So these rules complement and sit on top of those rules that protect our personal data, also in the space of online platforms. Many thanks for this. Moving to the next question, can you elaborate on how you think the number of active end users should be calculated based on the business model? Well, that's a good question. And so first of all, I think it's a common metric, active end users. It's a user this is a metric that companies report regularly already in their financial reports or for investment reports. And it's also used, by the way, in some European legislation in Germany and in France. So it's a well-established concept that companies know and they report on internally as well regularly. So it's not exactly an unusual or new metric. We are giving ourselves the possibility in both legal instruments, in the Digital Services Act and in the Digital Markets Act, to come up with a delegated act that specifies
the exact methodology for how this should be calculated, so that there is no ambiguity, and so that one company cannot suddenly say, oh, I'm not a gatekeeper, or I'm not a very large online platform, because they use a completely different way of calculating how many users they have. So we recognize that we need to be clear on the methodology, but I have no concern that such a methodology could be found, because it's a very standard industry-wide metric that we can certainly work with and make hard, so that we have a legal certainty and for everybody.
Many thanks. Can you please give us an example of what effective portability of data will mean in practice for users of such gatekeeper services?
Well, I think that you will have seen that first of all, there's a variety of gatekeeper services that we are capturing. I mean, effective data portability means that you can take data easily from one place to another. And experience also on the existing data portability rules, for example, and the GDPR, have shown that this is a complex and cumbersome process that hasn't really materialized. Although there have been some industry attempts under I think it's called the Data Takeout Project, to facilitate this, and they haven't really materialized in any practical solution. So at the moment, if you want to take your data from one gatekeeper platform to another, it's really hard work, and it's very, very difficult to do. So I can't give a specific case example. I don't want to give it, but the obligation needs to, it says that it needs to be very easy for you to take your platform data from one service to another one, against the baseline of where this is a very heavy bureaucratic feature at the moment, very cumbersome for end users, and therefore also never used in practice.
Many thanks. Moving to the next one, it seems online platforms will have more obligations in the future. You have a view what it means in terms of cost or effort for a typical SME?
I think this is more a question for the Digital Services Act. I don't know, Irene, do you want to just comment on the SME angle? Because the Digital Markets Act will not cover by the definitions that we have any SME. For example, the very large thresholds in terms of turnover. Irene, do you want to just come in?
Sure. As I mentioned before during the presentation, we try to get the balance right between being proportionate and being effective. So one of the measures that we put in place in order to get that balance right is to exclude micro and small enterprises from certain obligations, such as the ones that apply to online platforms. So in these four concentric circles, the one on online platforms would not apply to micro and small enterprises, but also the transparency obligations, the reporting that we ask on all intermediaries in the technical infrastructure, that would not apply to the small and micro ones. So in this sense, we intend to again put the obligations there where risk happens.
Many thanks for this. As we are aware of the timing, and it's almost the end of business day, we really want to say a big thanks to the speakers today that explained us this services today, the Digital Services Act and the Digital Markets Act. So big thanks to the speakers, and also to the over 800 participants who joined us today. So no worries about the questions that are left unanswered. Our colleagues will have a look on Slido, and you will receive the replies. So extremely useful to know about the set of the new rules for all digital services directly from our key players in delivering these new legal frameworks. The recording will be published on the Connect University webpage as of next Tuesday, and you will be able to review it together with the presentation. Once again, many thanks to all of you. Follow Connect University on Futurium and stay up to date with the latest digital trends.